Hello everyone, my name is Ruth Jean and I'm an attorney practicing in immigration law in South Florida. Today I want to talk to you all about the Sanchez case. The Sanchez case is the recent case that was decided by the U.S. Supreme Court regarding TPS. Basically what the Supreme Court decided is that TPS in and of itself is not an admission for adjustment of status purposes. Now, this case has been causing a lot of confusion, and so I wanted to shoot this brief video to hopefully clear up some of that confusion. Basically, what the Supreme Court ruled is that TPS in and of itself is not an admission for adjustment of status purposes. What that means is basically what the law is that an individual who wants to get a green card in the United States has to apply to adjust their status. In order to adjust their status, they have to be admitted, inspected, or paroled. Under those circumstances, in a lot of jurisdictions such as California, the immigration officials were treating a person who was on TPS, who had entered without inspection, as an admission. And in jurisdictions like Florida, they were treating those individuals as not admitted. So because there was a conflict with how different jurisdictions were treating individuals with TPS, the Supreme Court stepped in to decide once and for all whether TPS in and of itself is an admission. And unfortunately, for people with TPS who entered without inspection, the Supreme Court decided that it is not an admission. So as normal, an individual who enters without inspection normally cannot adjust their status in the United States unless there's special circumstances. Now, does this mean that an individual who has TPS cannot ever get a green card? That's not what this ruling means. Does it mean that an individual who has TPS can never get a pathway to citizenship? That is not what the ruling means. The ruling is specific to individuals who entered without inspection, and it's specific to that circumstance. So Congress can pass a law that admits or allows individuals with TPS to adjust their status and ultimately a pathway to citizenship. As a matter of fact, the House has already passed the Dream and Promise Act that allows for that, but it is not yet law. So the ruling itself is very specific. Individuals who entered without inspection are not considered admitted just because they have TPS. Does this mean that you should not apply for TPS if you entered without inspection? No, that's not what it means. As a matter of fact, it's in your interest to apply for TPS even though you entered without inspection. Now, I know this was a lot of information for you to take in. So I'm sure you may have questions. Please, if you have questions or concerns on anything I just talked about or any immigration matters, please don't hesitate to contact us. You can reach us at 954-278-9332. That's 954-278-9332. Thank you.